The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning. This case is Reynolds American Inc. versus Third Motion Equities Master Fund Ltd. et al. We will hear from the appellant.
Good morning, and may it please the court, Sheila Siddiqui of Rolnick Kramer Siddiqui LLP, on behalf of the Mason and Blue Mountain appellants, Mr. Schindel and I will reserve 6 and 2 minutes respectively for rebuttal. In this appeal, everyone agrees that the North Carolina appraisal statute required the business court to value appellants' shares as of the July 25th, 2017 transaction date. We disagree about whether that was done. Two elements of context are important to this appeal. First is the appraisal statute itself. That statute reflects a careful balancing by the North Carolina legislature of, on the one hand, the legitimate interests of companies to be able to effect corporate transactions with minimal transactional friction, but on the other hand, the legislature's desire to protect, in narrow circumstances, shareholders who believe that their shares are worth more than the price that they are being forced to accept, and who will have no further rights to those shares other than the right to have a court independently value those shares as of the transaction date. While the appraisal statute is broadly remedial in intent, I say that it applies only in a narrow circumstance because Section 55-13-02B1B provides that the right to appraisal is not available for holders of shares in a company that is traded in an organized market, has at least 2,000 shareholders, and a market value of at least $20 million. So I think it's fair to assume that by not providing for appraisal rights in that situation, the legislature has made a determination that the market generally provides a sufficiently protective dynamic to ensure that a shareholder will at least receive fair value for his or her property that's being taken against their will. The exception that's identified by the North Carolina legislature is that when the shareholder's shares are taken in a transaction with an interested person, a situation in which even with a broad organized trading market for a large cap company such as Reynolds, the resulting merger price is not presumed to reflect fair value. And as a result, the legislature has provided that a higher level of shareholder protection is warranted. And that is the statutory right to an independent judicial appraisal of the value of the shares as of the transaction date. The second piece of context that I think is important to this appeal is this court's 2018 opinion in Corwin versus British American Tobacco at 371 NC 605. And in that case, the majority recognized that by virtue of BAT's position, BAT, British American Tobacco, had both leverage and substantial bargaining power that gave it the ability to secure terms that favored BAT over other minority public shareholders in connection with the Lorillard transaction. Now, per Corwin, BAT was entitled to use that leverage, which, as the dissent noted, even to the disadvantage of other public shareholders who were boxed out of the economic value of game-changing technologies and were diluted as a result of BAT's exercise of its substantial bargaining power. Now, why was BAT entitled to favor itself, notwithstanding its superior leverage? Because it was not a majority shareholder, and because, as the business court noted, the business court in this case noted in its opinion, because the Supreme Court of North Carolina concluded that the governance agreement prevented BAT from having effective control of RAI. Now, why is that important to what we're talking about today? Because the consequence of that decision, whether or not intended, was that BAT was able to wield its indisputable leverage and substantial bargaining power, including to the detriment of the public minority shareholders, freed from the checks of any fiduciary duties. So typically, when a majority shareholder seeks to take over the rest of a company, it would be bound by fiduciary duties to the minority. It would, for example, not be able to prevent the company from taking steps to maximize the value of shares for all of its holders. In that case, the majority may be required to permit an open auction process or agree to support a superior transaction. BAT in this case, as a deemed non-controlling holder, had no such fiduciary duty constraints. which is fine. That was as it should be. That was under the law. But so when it launched what everyone agrees was an opportunistically timed bid in this case, while armed with information from a strategy day that had revealed higher than anticipated synergies, greater results from the Lorillard transactions, a step change in Reynolds' projected growth, none of which outsiders or the market had knowledge of, BAT was free to, and did in fact, couple that action with an affirmative announcement to the market that it would not support any other transaction and it would not agree to sell its shares. That action by BAT, which again, it was entitled to do because it didn't have fiduciary duties, left BAT shareholders, the other BAT shareholders, with a closed process that could only generate the highest bid that could be achieved with BAT. And that is what the Reynolds board achieved, the highest price for the shares that they could achieve with BAT. But that price is not necessarily the highest value that might have been achieved had the company been able to, in Delaware parlance, forge the deal in the crucible of an open market process. Now, the North Carolina appraisal statute represents the legislature's decision to step into this breach, step into this void, and offer some protection for shareholders when the transaction falls short of triggering controlling holder fiduciary duties, but is subject to the risks to fairness inherent when a transacting party is a holder of at least 20% of the voting power or has the power to appoint at least 25% of the board. And BAT, of course, more than satisfies both in this case, and thus the appellant shareholders had the right to have the court appraise the shares as of the valuation date. Now, in this case, we know what the Reynolds shares were worth as of the statutory valuation date. They were worth $65.87. What the business court did below was to fail to value those shares as of that date.
Well, Ms. Siddiqui, just to make sure I'm not losing you before you get started, well, you say they were worth $65 and some odd cents. That's the figure that under the agreement, the shareholders who tendered their shares on that day, that's the amount they actually received, correct?
Correct, Justice Irvin. That is the amount that the shareholders actually received as a result of the transaction. And in this case, that's...
But that's not necessarily, let's assume for purposes of discussion that Reynolds had remained an independent company and the transaction had not been consummated. That $65 fee might or might not be what the fair market value of those shares in the absence of the merger would have been, right?
Correct, Justice Irvin, but I would say that the business court below made a determination that the fair value of the shares as of the transaction date was the deal price. That is what the court said. That is what the court
was no more than the deal price.
Said that it was no more than the deal price. However, the court did say that it was concluded that it was the deal price that was reflective of the fair value. So while BAT has argued that the court said no more, the actual text of the court's opinion shows that he was in fact relying on the deal price. To Your Honor's point about that doesn't necessarily translate to the value of Reynolds on a standalone basis as of that date, the court below also does make an accommodation for that because the court finds that the synergies in this case that adhered from the value of the transaction were 28 cents. The court also found that it didn't have to adjust for a control premium or a minority discount. Those are issues that the appellants disagree with. But when you have an appraisal statute that says you're entitled to the value of the shares as of the transaction date, the court below found that concluded that the transaction price was the fair value. The mistake that the court below made was then taking the transaction price as of the January 2017 deal signing date and not bringing that out to the closing date, which is the statutory valuation date.
Doesn't the order say a number of times that the value was the $59 some odd cent amount reflected in the deal price as of the date of the closing of the transaction. I mean, you know, what we do, what I think we're supposed to do here is review the order as it's written and ask, first of all, are the findings supported by the evidence? And secondly, are the conclusions supported by the findings? So that at least our review is fairly closely tied to the order. And so it's important, at least for my understanding of the standard of review, to focus on what the order says and then look at the evidence to see whether the order is supported by that evidence.
Yes, and I would point your honor to record page 228, paragraph 193 of the business court's opinion states that RAI introduced evidence of value that, quote, show that the price paid by BAT reflected the fair value of RAI. And while appellee has argued that the court isn't necessarily deferring to the January deal price, but rather to the amount that BAT had actually paid to appellants, in the very next paragraph, paragraph 194, the court refers to its, quote, conclusion that the deal price reflected fair value. So we have within the opinion,
without specifying a particular date at that point.
Correct. The court says it's concluding that the deal price reflected fair value. So concluding that the deal price reflected fair value essentially says that the court has found that the process was sufficiently reliable that the shareholders should get the value on the transaction date of the deal that had been negotiated. And the value of the deal that had been negotiated that the court concluded reflected fair value was $65.87. That's what shareholders got. To your honor's point that the statute requires it to be the standalone value of the company without the value of the transaction, the business court also determined that the value of that transaction was the 28 cents for synergies. So this is a fundamental error of law in the conclusion that's drawn. And I take your honor's point when we look at what was actually found by the court, which is deal prices reflective of fair value, then it's simply a question of what was that deal price as of the transaction date? We know that. We know that objectively. It was $65.
Okay. Yeah, again, I hate this is sufficiently complicated. If I lose your train of thought, I'm likely to lose your whole argument. I don't want to do that. It seems to me that what we've got is a finding that says, in effect, the fair value of these stocks, as this trial court said several times, the fair value as of the date of the transaction was the deal price set. Was it no more than the deal price set at the time the deal was made?
And I agree that's what the court said. And what I'm saying is this is one of the errors of law, and it's an error of conclusion here. There's a disconnect between what the business court found and its conclusion. To find on the one hand, as the court said, that the conclusion is the deal price reflects fair value. In paragraph 194 of the opinion, the deal price reflected fair value. The deal price struck in January. How is that connected to the statutory date by which it has to be measured? It's not. This is not a case where a deal price was struck for the fair value and it's a static amount. It's a piece of cash being paid. The deal price here, the last component of an appraisal is that you have to calculate the difference in value between the date that the deal was struck and the closing of the transaction. So here you have a deal struck at $59.87. It's not a static price. The deal consideration here included a floating component that was able to track the value of the increase in Reynolds in that period of time, that 6 months between deal and closing. So to find that the deal price accurately reflected the value, to somehow connect that $59.87 to July, there is no support in the record for that, because what he's found was that he's deferring to deal price, which is problematic in two ways. Number one, appellants submit that that's not a customary valuation technique, but even if this court were to find that it is, then we submit that this court should look to the Delaware case law that has clearly established since the 2010 Supreme Court opinion in Golden Telecom that the sine qua non of being able to give any weight to a deal price is that there is a market check. And this is what is missing by virtue of the Corwin decision, because BAT had the legal right to prevent a market check. And this is where the court, I believe below, has erred in taking Delaware cases and really reading out of them the provisions that show that the market check is what is necessary. Here, BAT affirmatively announced that it would not support another bid. The financial advisors were directed not to reach out to any other potential buyers. There was an affirmative no shop provision in the deal. There was $1 billion break free. All of that means that there was no market check. So when you take that away, you have the business court compounding two problems. Problem number one is that there shouldn't be any deference to deal price where there has not been a market check, and there indisputably was not a market check here. And our papers cite the differences between every case. I think the most helpful Delaware case to really illustrate this aspect of the law is the Columbia Pipeline case at 2019 Westlaw 3778370, which runs through a summary of the Golden Telecom to DFC to Dell to Aruba, all of the cases about why the market check is important and why that didn't happen here. But again, the business court did find that he was deferring to deal price. And when you do that, you have to bring it out to the July piece. I see we're at time where Mr. Schindel is taking the podium, and I'll reserve till rebuttal absent additional questions.
Thank you, and good morning, Your Honors. Mr. Chief Justice, may it please the court, Pete Schindel from Abrams and Bayless on behalf of the Magnetar appellants. Thank you for the opportunity to appear pro hoc vice this morning. There are two issues that I'd like to address. The first being the computation of interest to which the dissenting stockholders are entitled under the statute, and the second being the business court's erroneous reliance on the testimony of Professor Gompers. Turning to the statutory issue, as the court is, I'm sure, well aware, when a statute is clear on its face, it should be interpreted and applied as written. And we would submit that the appraisal statute, specifically section 55-13-30E, is clear on its face. And what it calls for in terms of the calculation of interest is that dissenting stockholders are entitled to a judgment after trial for the amount of the fair value of their shares plus interest, then less any amount previously paid by the corporation. The statute does not say that they are entitled to a judgment of fair value less the amount previously paid, and only then is interest added back in. Now, business court suggests that our interpretation of the statute, that the plain language reading of the statute leads to an absurd result, because here, the amount of interest to which the dissenters are entitled is approximately $100 million. Now, that is entirely a function of the amount of shares that are at issue, the value of those shares, and the statutory interest rate. And the proper interpretation of a statute shouldn't ebb and flow based on the amount in controversy in the litigation. I would also...
Am I misunderstanding your argument, or is your argument that what the trial court should have done is run interest at the statutory rate from the amount that you were paid some time ago, even though you were unable to persuade the trial court to award you any additional monies?
The argument is that the statute as written requires...
I mean, is the answer to my question, I mean, we can argue about what the statute said, but is the answer to my question as to what you're asking for, yes?
The answer, I just want to make sure I understand. I believe the answer is yes. The answer is that the interest needs to be added on top of the fair value award, whatever that is.
And assuming for purposes of discussion for a second that the trial court's fair value award is correct, that amount's already been tendered to you. So you're saying in effect that you ought to get interest on an amount that you've already received?
That would be the effect in this circumstance. That's correct, Your Honor. And the point is,
your contention is that that's not an unusual result?
Um, my contention is that's not an absurd result. I believe the standard is that the statute needs to be applied as written unless it leads to an absurd.
I'm trying to avoid using the word absurd, but
Fair enough, Your Honor. I didn't mean to quibble with the semantics of it, but yeah, I think there is a rational reason for the legislature to have chosen this approach, namely to incentivize corporations to make a sufficiently attractive offer in this, what I think of as a bid-ask procedure before we get to litigation, that, perhaps the appraisal contest can be resolved without having to go to court. Now, that is not a policy judgment that is free from cost. No policy judgment is, but ultimately that is a question for the legislature. The legislature has enacted the statute as it stands today. Other states have taken a different approach. For example, Pennsylvania, we pointed out in our papers, wrote the statute to make clear that interest is only added on top of any delta between the fair value award and an amount previously paid. But, for example, the Connecticut Superior Court adopted the identical interpretation to the one we advance, and I think it would be incongruous to find that the courts of a sister state landed on an absurd interpretation of the statute. Very briefly, Your Honor, turning to Professor Gomper's testimony, although he was tendered as a valuation expert, he did not provide a valuation or any opinion as to the value of RAI. What he testified to, broadly speaking, were two things: his adjusted unaffected stock price analysis and his analysis of the work done by the investment bankers. With respect to the latter, the upshot of his testimony was that the process and conclusions of the investment bankers hired by BAT and RAI were reasonable. That is quintessential vouching. It does nothing more than add the imprimatur of Professor Gompers as an expert to the work done by other people. And although the trial court found that expert vouching is impermissible, it somehow found that what Professor Gompers had done was not vouching. I can't see how to connect those two things. That testimony never should have been admitted. With respect to the adjusted unaffected stock price analysis, there were two fundamental predicates to that were never present in this record. The first predicate is that the market for Reynolds stock had to be at least semi-strong efficient, meaning that it incorporated information quickly as that information became publicly available. Professor Gompers never offered any opinion, never analyzed market efficiency. Instead, he relied entirely on Dr. Shivdasani for that. But because Reynolds decided not to call Dr. Shivdasani, that testimony and Dr. Shivdasani's report never made it into the record. Therefore, the predicate of Professor Gompers' testimony was missing, and it never should have been admitted. And as I see, I'm already slightly eating into rebuttal time. That's all I have, unless for now, unless Your Honors have any other questions.
Thank you, counsel. We'll hear from the appellee.
Thank you, Mr. Chief Justice, and may it please the court, Gary Bornstein on behalf of Reynolds American. I'd like to start, if I could, with one of the observations that Ms. Siddiqui made about the business court's order. I agree that that is where this court ought in the first instance to be focusing its attention in order to understand what the business court did, on the assumption that the business court accurately stated its own opinion. Ms. Siddiqui directed the court to paragraph 194 of the business court's opinion as the only support that she has given for the idea that the business court did not mean what it said when it repeatedly said that the value of RAI stock as of the transaction date in July was no more than $59.64. Ms. Siddiqui's reading of paragraph 194 is one in which the court pegged fair value to the deal price as of January and then failed to account for changes in value for the following 6 months. However, what counsel read to the court this morning was the first sentence of paragraph 194, ignoring the second sentence of paragraph 194, which makes perfectly plain that the business court's opinion was that for the reasons set forth below, which go on for quite a number of pages, as your honors are aware, the fair value of RAI at the merger closing on July 25, 2017 was no more than the deal price of $59.64. The business court could not have been more clear in paragraph 194 or in multiple other paragraphs of the opinion. Paragraph 3, the business court said that fair value equals or exceeds $59.64 as of closing in July. At the conclusion of the opinion, paragraph 384, the business court says it again, no more than $59.64 as of closing. The
Now,
argument,
if I understand the position taken by your colleagues, they say in effect that the trial court erred by adopting that approach rather than finding a specific fair value, or at least that seems to be one of their contentions. The trial court didn't find a specific value, the best I can tell from reading the record, and it's sufficiently lengthy that I could have missed it somewhere. But it is the contention that the trial court didn't make a specific finding of fair value correct? And if it is correct, does that matter?
So the factual answer to Your Honor's question is there is no specific finding of a point estimate of fair value other than the court's repeated and very clear statements that that amount was no more than the amount of money that the dissenters were already paid. It's quite logical for the business court to have structured its opinion and its findings that way, given that RAI was not seeking a refund of the amount that had been paid. There is no clear mechanism in the statute for such a refund to be granted. So whether the fair value was $59.63 or $59.60 or $59 or $49, the outcome would still be the same, that there was no further money due to the stockholders. So I do not believe, Justice Ervin, that there was any obligation on the business court to identify a specific number below $59.64, given that. And there are.
Is there any discussion of this issue? I mean, everybody seems to refer to Delaware authority for reasons that I fully understand. Have the Delaware courts dealt with this issue, and if so, what have they said?
Your Honor, yes. So in the Panera case, which the parties cite and the district court cites, the company took advantage of an option under Delaware law, which is a relatively new option in an amendment to the Delaware statute, where you can, as a company, pay in advance, and rather than allow interest to continue to run on an award. And what the company did there was it did prepay, and what the court in its analysis did in Panera, in the Chancery Court in Delaware, was to go through, find fair value. That decision was in fact based largely on the deal price, but the court then said, it is my responsibility to subtract out synergies, given that synergies are not a component of fair value to which appraisal dissenters are entitled. And what the court then did is say, well, here it doesn't really matter because there's not going to be a refund of any kind that is being sought by the company. The court said, I'm going to do it anyway, just to be thorough, because maybe on appeal there'll be some disagreement with my conclusion that the deal price is a good benchmark. And so the court in that case was diligent and went ahead and continued to do the calculation of synergies. But the court was quite clear it didn't matter. And it went through the exercise solely to facilitate appellate review. There's not much other discussion of the issue in Delaware that I am aware of, Your Honor, because that is a relatively new innovation in the Delaware statute. As the Delaware statute was written previously, there was no prepayment option. In fact, there were parties who tried to prepay to stop interest from running, and the courts held that just was not something that was permitted under the statute. So the opportunity for this to arise didn't exist until recently. I'm sorry, Justice Ervin, if you were asking me a question, you were on mute there.
Well, I was thanking you for your answer and trying to keep down the amount of noise and try to do both at the same time.
Well, I foiled you in that effort, but I appreciate it. The place that I think is useful to step back to, as counsel did at the beginning of her remarks, where counsel talked about the differences between the North Carolina statute and this one, excuse me, and the Delaware statute, and how there is no presumption that the deal price should be fair value in a case like this. And there was also a reference to the Corwin case and how that bears on the analysis here. Both of those issues, as framed by dissenters, fall apart based on the fact that we had a trial here. Let me explain what I mean by that. Whether or not it is true that the North Carolina statute does not presume that a deal price is fair value is beside the point today, where the business court conducted a trial that was nearly 2 weeks. We had a short break in the middle, and heard evidence from numerous experts and fact witnesses, reviewed the documents, and formed a considered judgment, not a presumption, but a judgment based on the facts presented at trial that the deal price was a relevant indicator of value. So no one here is relying on a presumption at all. We are relying on trial evidence and factual findings of the trial court and the exercise of the trial court's judgment and discretion. Second, as to Corwin, the same issue is true. I recognize that there was a disagreement among the members of the court on the adequacy of the complaint in Corwin, but that's what it was. It was a disagreement among the members of the court on the adequacy of the complaint. That was a motion to dismiss pleading stage decision. We are here after trial. At trial, again, the business court heard the evidence, heard from the chairman of the board of Reynolds, heard from the subsequent chairman of the board of Reynolds, heard from the bankers, heard from the CEOs involved in the negotiation of this deal, and formed a conclusion based on the evidence that in this transaction, the board acted independently of BAT on the basis of the facts and not on the basis of a pleading or a presumption. Corwin, for that reason, is not relevant to the assessment the court needs to make today after trial. Also, I'll point out, Corwin related to a different transaction than this one, as the court is aware. And both the majority and the dissenting opinions in Corwin were quite clear, appropriately so, that the analysis there related to whether or not BAT exercised control with respect to the transaction that was under review in that case. That's a different transaction. Those are different facts. Here, we have a transaction that has been reviewed post-trial and the conclusion reached that BAT did not exercise the kind of control that would make the deal price an unreliable indicator of value. Now that said, it is.
If I understood my conversation with Ms. Siddiqui, and she's got some rebuttal time to correct me if I misunderstood her, her contention was that at least under the Delaware statutes that, again, we've all talked about, that deference to deal price, deference to market prices, things like that is inappropriate in the absence of what amounts to a market check. And at least if I understand her brief, what she means by market check is some sort of unfettered business, bidding process. No such bidding process occurred here. And from that, it appears to me that your colleague's argument is that we should ignore all of the market-based evidence on the grounds that there was not a sufficient check. Again, if I'm misstating her position, she can correct me, but I think that's close to right. What's your response to that argument?
So I understand the position the same way, Your Honor, and respectfully, I think it's wrong. I'll start by pointing out, as I think the parties agree in their briefs, that the Delaware courts have said, and I quote, there are no minimum requirements for a sale process to make a deal price a persuasive indicator of value. That quote comes from the Columbia Pipeline case that counsel cited to the court this morning as well. In Stillwater, another Delaware case, which was subsequently affirmed by the Delaware Supreme Court. The court said there are no specific legal requirements for a sale process to be reliable. So there is no bright line rule of the type that Dissenters Counsel has advocated in this case. Instead, the persuasiveness of the deal price depends on the facts and circumstances on the ground, and the analysis needs to be done, again, as Columbia Pipeline says, as a whole. And that's what the business court did.
So does that mean that in your view, at least, the adequacy of the market check is a question of fact for the trial court?
Absolutely, Your Honor. And here we have a business court that walked through in great detail the aspects of that process that gave the court comfort that the deal price that was achieved was a persuasive indicator of value. There are paragraphs and paragraphs of the opinion that walk through them, that link them to cases in Delaware, such as the Panera case and Stillwater, that the court relied on in identifying the characteristics of the deal process, the objective indicia of reliability that the Delaware courts and then this court relied on. I think it's also worth pointing out that dissenters treat the deal price like an on-off switch, as though either the business court could consider it a persuasive indicator of value or it could not. And that if there is no market check of the type that dissenters advocate for, then it's simply off limits, 100% out of the ballpark, so to speak. But that's not so. Just like any other piece of evidence in any case, there is a sliding scale. Some evidence is more persuasive than others. And there are cases in Delaware to this effect, where you have a deal process that is not perfect. It can still be persuasive, even if not dispositive. And so I think the other flaw in this bright line rule argument that Your Honor paraphrased from the dissenters is even if there were a requirement that there needs to be a market check, which there is not, but that would not take the deal price out of the case entirely. It would just affect the degree to which it ought to be considered persuasive. And here, given the number of objective indicia of reliability identified by the trial court, after hearing the evidence, the factual findings it made, there's really no basis to throw the deal price out entirely, as dissenters would like the court to do. And
what do you contend that the trial court did with the deal price? Your colleague, if I'm understanding her argument correctly, seems to suggest that we ought to conclude that the trial court simply ratified the deal price as the fair value, that the trial court essentially just said this was what you negotiated. Negotiation doesn't look improper to me, therefore that's the fair value. Is that what happened in your view?
No, Your Honor. I think that is one of many ways in which the dissenters have simply mischaracterized what the business court actually did. And although they pluck, as I recall from the brief, one paragraph out of the business court's opinion to say, aha, it accorded determinative, if not a substantial, if not determinative weight to the deal price, it could not be clearer from numerous other portions of the opinion that he did no such thing. For example, in paragraph 383, just before the conclusion, summing up what the business court did, Judge Gale walked through the totality of the evidence on which he relied, the market indicators of value, the discounted cash flow analyses that were contemporaneously performed by knowledgeable and experienced financial advisors, the comparables and precedent transactions to which he gave less weight than others, but nevertheless considered as cross-checks, the work of the stock market analysts contemporaneously, the analysis done by one of the dissenters themselves as to fair value. Never a word about that in the briefs from dissenters or this morning. It was certainly taken into account by the business court. Not to mention the overwhelming shareholder vote in favor of this deal, and not to mention the considered judgment of the members of the board and of management of RAI, who the business court found, as a matter of fact, were acting in good faith. There was a plethora of evidence on which the business court relied. The dissenters say, well, most of that stuff doesn't count because they're not current and customary valuation concepts and techniques within the meaning of the appraisal statute, but that's not so. There was extensive factual evidence in the record credited by the business court that valuation professionals in the ordinary course of business take into account all of the types of evidence that I just identified. There is no support for the dissenters, again, another bright line rule, barring market metrics from being customary valuation concepts and techniques. That's contrary to the commentary to the Model Business Corporations Act, on which the appraisal statute in North Carolina is based. It's contrary to the law of other states that have applied MBCA-based statutes, which is cited on our brief. For some reason, there are a number out of Iowa. They seem to have an appraisal cottage industry there. We've cited a number of those. And there are lots of reasons, by the way, that the Delaware courts and other courts have identified to be skeptical of a discounted cash flow standing by itself, particularly when it has two characteristics present here. Number one, it is an extraordinarily extreme outlier. It deviates from all of the other evidence of value in this case, evidence which, to go back to Your Honor's question, the business court relied on. It took into account the full totality of the evidence. The second aspect of the DCF at issue here, which renders it a very slender reed on which to base evaluation in the face of other evidence, is how sensitive it is to variations in inputs. And I'll talk about that in just a moment. But I would just conclude my somewhat lengthy answer to Your Honor's question by saying that what the business court did here was frankly far more robust than what dissenters contend it did. They contend it just relied on deal price. And it was frankly far more robust than what they contend it should have done, which was to rely on the discounted cash flow analysis put forward for litigation purposes by their expert in the teeth of all other evidence of value in the record. As to the question of the DCF analysis that was presented, it is based, and I didn't hear any defense of it this morning. There's not much defense of it in dissenters' reply brief, but it is based, and the value it derives is based entirely on the perpetuity growth rate, the PGR, on which dissenters' expert relied. That PGR cannot survive, does not survive the factual findings of the business court. So just so that it's clear to march through what happened in this analysis, Professor Zmiewski, at least that's how I pronounce his name, who was dissenters' valuation expert, he declined to come up with a perpetuity growth rate. He relied instead on a separate expert, Mr. Flyer. Mr. Flyer was instructed by counsel to come up with a perpetuity growth rate that took account of the 10-year projections on which dissenters' case essentially depends in total. Those 10-year projections, the business court found in multiple ways, were unreliable bases for evaluation. The business court found, with no contradiction, that those 10-year projections were simply extrapolations from existing trends. That was the uncontradicted testimony. And you can see it even in the page from an Excel that the business court reproduced in its opinion that just shows a bunch of straight lines that are drawn out into 10 years in the future. It is clear, again, from the record, from the documentary record, that the 10-year projections were put together with a broad brush approach. That language comes right from the instructions given by Reynolds' finance staff to the people who worked on this, use a broad brush approach. And it's clear that those projections did not take into account the very substantial risks that faced the tobacco industry generally, and Reynolds in particular, with its reliance on menthol and on higher priced cigarette brands. Those projections are the foundation of the $92.17 valuation that was urged on the trial court. And those projections do not survive, cannot survive the uncontradicted factual findings of the business court. One other point I think I should make with respect to the valuation urged by the dissenters here is the $65.87. And this goes back to the colloquy that counsel had with Justice Ervin near the beginning of her argument. There is an assertion that comes through the dissenters' papers, and again this morning, that the business court essentially made a mistake and valued the company as of January when the deal was signed rather than July when the deal closed. And if that is so, say the dissenters, well, if it was $59.64 as of January, and there was an increase in value 6 months to July, they should be entitled to that increase in value. That's not what the district court, that's not what the business court did, and it is not an accurate reflection of the analysis in the case. As came through from the discussion with Justice Ervin at the beginning of argument, the business court repeatedly said the value was no more than $59.64. But of even greater significance and not yet discussed this morning, there is a whole section of the business court opinion talking about what happened between January and July. The election of Donald Trump, the possibility or expectation of tax reform, the expectation of changes in the regulatory environment for tobacco, the changes that actually happened in the stock market and the economy at large. All of that is reflected in the business court opinion. There is no way to read this opinion and think that Judge Gale failed to take into account the extensive set of evidence of what happened later in 2017 that actually appears in his opinion. It is discussed at length. The business court also makes clear that it gave weight to and it considered the adjusted unaffected stock price analysis that Professor Gompers presented at trial. I recognize that the dissenters have a challenge to that analysis, but there can be no question that Judge Bledsoe paid attention to it. And if I said Judge Gale earlier,
the dissenters also seem to argue, at least if I'm reading their brief correctly, and this is not something that Ms. Siddiqui brought up this morning, but I think it's in the brief, that in effect that the change in the value between the January date and the date of closing stemmed primarily from an increase in the value of BAT stock, and that the increase in the value of BAT stock in turn was driven by changes in the value of Reynolds because of these factors that you've been discussing, and that therefore it was impermissible for the trial court not to take that set of circumstances into account in its analysis. Again, if I've misstated Ms. Siddiqui's argument, she can correct me, but that's what I got out of it. Why is that argument not meritorious?
Well, again, I think that's a fair paraphrase of the dissenter's argument. And the reason it's not meritorious is that Judge Bledsoe, and again, I apologize if I said Judge Gale, but Judge Bledsoe did take into account the increase in value between January and July. Paragraphs 209 through 211 of his opinion discuss the changes in the market, in the industry, that led to an increase in value. He acknowledges and he gives dissenters credit for the increase in value that occurred over that period. The fact is, however, that even with that increase in value, the business court concluded that the fair value did not exceed the $59.64 that had already been paid to the dissenters before this case began. So they got credit for that increase. It just didn't take fair value above the amount that they had already received. That was the conclusion of the business court. There was no legal error. Maybe there is a contention from the dissenters that he didn't take account of that increase in value appropriately. Maybe they have a factual dispute about what the value is, but there can be no fair contention that he failed to take it into account, given what appears in the order. I will also say that the argument about the $65.87, which is effectively, gee, Your Honors, we really should get what everybody else got here, and it's not fair for us to get less. It is just not consistent with the statutory scheme. If the dissenters wanted $65.87, they had the opportunity to take it back in July of 2017. They made a decision as very sophisticated investors that that was not what they wanted to do, and that they wanted to make an effort to prove to the business court or to this court that the shares were worth more. And they did that. They did it here. They have done it in other cases, and sometimes it has been successful, sometimes it has not. But that was a calculated decision that they made. And there is no provision in the statute that entitles them to a floor set by the value of the merger consideration at closing. The floor in an appraisal proceeding is what the company chooses to pay as fair value, because there is no refund. And if the dissenters can prove that the company didn't pay enough, well, then they can get more. They will get more. They are entitled to more. Here, they did not prove that fair value exceeded the $59.64 that was paid. And so they are not entitled to more, because the court has found that fair value is not more, and they are not entitled to more than fair value in an appraisal proceeding. They were entitled to that back in July of 2017, but they chose, when they pursued this case, or when they pursued the dissent procedure, the appraisal procedure, they chose not to take it, and they are now where they are after trial, given the findings of the trial court, after hearing their arguments and their evidence. I suppose the last thing that I should hit in my remaining time is just to emphasize the mutually reinforcing set of evidence on which the business court relied. This was not a close case. This was a case in which all of the evidence pointed in the same direction, with the sole exception of the made for litigation after the fact DCF analysis of the dissenter's expert that the trial court found not to be supported by the evidence.
Thank you, counsel. We'll hear from the appellants with rebuttal.
Thank you, Chief Justice. Exercising appraisal rights is not something for which shareholders should be punished, and we're not here complaining about fairness. We remember the trial. We understand the weight that is given to Judge Bledsoe's factual findings. What we are talking about is pure errors of law. The North Carolina appraisal statute does not say that shareholders are entitled to an independent judicial valuation of the shares as of the transaction date, as long as the court doesn't find that it's not going to matter. That's not what the statute says. The statute requires that a valuation be done, and it wasn't done. And Mr. Bornstein has to concede that. And the case that Mr. Bornstein recognized out of Delaware, the Panera case, where it also wouldn't have mattered, the court in that case did do a valuation to the penny. And it was important there for the same reason that it's important here, because of our right to appeal. The fact that we are debating how the business court used the deal price, what import it gave to the deal price. Mr. Bornstein says the business court acknowledged that there were increases in value between January and July. Absolutely. That is evidence. The business court relied on Mr. Gomper's finding that Altria, Reynolds' competitor, increased by 20.44% between October and July. There was no valuation about what portion of that related to the time between January and July. I would say a great deal, because it's relating to, as the court also said, the likelihood that this deal is going to close, which as it gets closer to the deal date becomes more and more likely, and the likelihood of tax reform, which became closer and closer as time went on from the deal date. So the fact that the court did not do a valuation, we do not know what number the court has pegged the value to and why, prevents our ability to fully discuss it on appeal. That is an error of law. And for that reason alone, this decision should be remanded for the court to make a determination about the value as of the transaction date and how it got there.
Ms. Siddiqui, I try not to interrupt people in rebuttal because I know your time's limited. We have a harmless error rule in this state. How does the finding that the trial court actually made as compared to the one that you contend should have been made prejudice you in this case?
Because we don't know what he found. The fact that Judge Bledsoe found that it was something less than what we were paid is tied to, number one, what he says is weight that was given to the deal price, which again, we say, and I have a lot of respect for Mr. Bornstein, but on this, he is flat wrong. There is not a single case in Delaware that permits any weight to be given to deal price without a market check. That is a hard and fast rule. There's no hard and fast rule about what constitutes a market check. And certainly there are cases that say you don't have to have had other bidders, but every single case in Delaware either has an open process by way of a pre-signing check or a post-signing check. There isn't one otherwise. BAT closed this process. It had a right to do that because it wasn't a controlling shareholder, but the consequences were entitled to evaluation. There is no harmless error here because we don't know what the value was. In this case, no weight should have been given to the deal price. That's an error of law. Should this court agree with Delaware, there was absolutely no market check. The corroborating factors here that the court found, yes, the court made a lot of findings of fact, but how they were applied legally under the statute to get to the conclusion that that's what these shares were worth as of the transaction date, there is absolutely no connection. How do you take the 5987 and the 5964 and say, I acknowledge that after that date, there are these substantial increases in value, but then not tie them together? What are the other corroborating factors that the court is relying on? Well, the court relied on the financial advisors' valuations of the company. Those also were done in January based on October 2016 financial statements. It suffers from that same flaw. Yes, the court is talking about increases between January and July, but no, the court didn't give us credit for them. And that's the problem. And I do want to also touch on, Mr. Bornstein said that, well, I didn't touch on it. The Mason Capital valuation that the court relied on, in this case, Mason Capital was one of those shareholders, other public shareholders that was involved and was a historic holder in Reynolds at the time of the Lorillard acquisition. It is very clear. And, you know, the business court says things, but we have to look at what he actually did. The business court quotes Ms. Constantino's testimony out of context to use it for a conclusion that's wrong. What Mason said was, we did a valuation of what we believed the starting market price should be before there is any negotiation with BAT. What they were clearly saying in that paper, which the court acknowledges, is that rather than a trading price of $47, which was depressed, the Mason view was the starting price. The market price should have reflected a $54.44 market price if the market had been actually reflecting what it should have. And when you add the 20% increase that Gompers found to bring that out to July, that price that Mason calculated also would be $65 and change. In fact, it would be 2 cents less than the actual transaction price minus synergies. That's corroborative evidence. I know that we are at a minute and a half, but there is in this case pure errors of law. We were entitled to evaluation. The court didn't do that. It should be remanded on that basis alone. And to the extent that this court finds that the law in North Carolina should be that there should be some deference to deal price, it should be based on a market check, which didn't occur here. And I will defer to Mr. Schindel.
Thank you. Just very quickly, in paragraph 193 of the trial court's opinion, which sort of summarizes his ultimate fair value conclusion, at least that's the way I read it, refers to the price paid by BAT reflecting the fair value of RAI, and concludes with a statement that the evidence presented by the company, most of which supported the conclusion that RAI shareholders received fair value in the transaction. So the point there is the trial court's deferring to deal price on the theory that what shareholders got in the transaction was fair, which is a legal conclusion. What shareholders got in this transaction was not $59 and change. It was $65.87 per share. And I don't see any way to read this opinion as a whole, except as concluding that what the stockholders actually received was fair value, and that is clearly not $59 and change. Thank you, Your Honors.
Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court. Thank you, counsel.
Thank you.
Thank you very much.